Businesses and business owners frequently have to enter into contractual relationships. In today's video, we're going to go over 5 things that you need to bear in mind whenever you have to enter into a contract. I'm attorney Nathan Saunders, and this is The Legal Good. The first thing you're going to want to bear in mind when you're entering into any contractual relationship is that contracts favor the drafter. If you have to go to court to dispute a contractual agreement and there's some term in the contract that is ambiguous, the court is going to first look to who drafted the contract, and then as it's deciding what that ambiguous language means, it's going to make that determination based on whatever is the least favorable outcome for the person who drafted the contract. The reason that the court does this is because whoever drafted the contract likely put terms in there that are going to be overly favorable to that person. Second, typically, contracts are going to be drafted by the person who is in a superior bargaining position to the other party. So courts try to take away this power that the contract drafter has by construing the contract against the drafter. Because contract drafters know that courts are going to do this, what they typically do is they include a clause in the contract that says, "Court, if you get this contract, you are prevented from construing the contract against me." Because you now know this, what you're going to want to do whenever you're entering into a contract, if you're not the drafter of the contract, you definitely want to read the contract, make sure you understand every provision in the contract, and either get rid of or renegotiate those terms that are overly favorable to the person who drafted the contract. 2, all contracts are negotiable. Oftentimes I get into litigation with a business client who is in a contract dispute, and the contract that my client sends me will have a whole bunch of language stricken through. They'll have a whole bunch of stuff written in the margins or in between the paragraphs and little writing. And the reason that those strike throughs and that language exists is because the business who received the contract found all these things, all these terms that it didn't like. And so they renegotiated those terms by just either getting rid of them or writing in new language. They'll change dates, they'll change terms, they'll change everything in the contract if they can. What you need to know is that you have this power too. Whether you're an individual, a business owner, or somebody working for a business, you have the power to renegotiate the terms of contracts. So when you get a contract and you want to make these changes, go ahead and make these strike-throughs, make these notations in the margins, and then you're going to want to sign the bottom of each page of the contract, regardless of whether the contract calls for you to sign the bottom of each page. You then present the contract back to the person who presented it to you originally. And either that person is going to accept it or reject it. If they accept it, great. If they reject it, all they're going to do is give you another contract to sign. In which case, you're no worse off than when you started. But here's the secret. Oftentimes, when you're given these form contracts to sign, the person who gives you the contract to sign never looks at the contract again before they provide you the goods or the services that you're contracting for. In fact, they typically don't look at the contract again unless they get involved in a dispute over the contract. And by that point, it's too late for that party to argue that they did not accept your changes. Number 3, make sure that the person signing for the other party has the authority to sign on behalf of the business. Under every state law, only certain people have authority to sign on behalf of businesses. And if other people try to sign on behalf of the business, then unless that person has been granted the authority by the business and expressed that authority to you, they're not binding the business and the contract can just be stricken. When you're dealing with a sole proprietorship, only the owner has the ability to bind the business. If you're dealing with a partnership, only the general partners, not the limited partners, have the ability to bind the company. If you're dealing with an LLC, then it's either going to be the members of the LLC or the manager of the LLC that has the authority to bind the entity. And that's going to be based on what the operating agreement says. If you're dealing with a corporation, it gets a little more hazy. By law, typically only the president or the CEO of a corporation have the authority to bind the company. But when you're dealing with larger corporations, it gets a little fuzzy. What you're going to want to do anytime you are entering into a contract with a business is you're going to want to go to your Secretary of State's website and look at the articles of incorporation or the articles of organization for that entity and ensure that the person signing on behalf of the other entity has the authority to bind the business. 4, it's extremely important that you know how contract disputes are going to be resolved and where they're going to be resolved. When you enter into a contractual agreement, you're going to want to have something in the contract that spells out how disputes are going to be resolved and where disputes are going to be resolved. If you don't have that spelled out, you're going to end up in court. And it might be in your best interest under that contract to go to arbitration or binding mediation instead of court. So it's best that you resolve those issues before the contract is executed. Also, even if you've decided how the dispute is going to be resolved, you're going to want to make sure that that clause doesn't have something crazy in it, like the only way that this contract dispute can go forth is in some county in Alaska or North Dakota and the courts therein. You don't want that. You don't want to be in Texas and have to go up to North Dakota or Alaska to have to dispute this contractual agreement. So you want to make sure that you read those provisions, and if they're not there, that you insert some provision as to how those contract disputes are going to be handled. Finally, number 5, hire an attorney. You may be the best bread maker in the business. You may be the best orthodontist, the best tattoo artist. But just because you're the best in your business at what you do doesn't make you the best contract drafter or contract negotiator. Stay in your lane. Hire competent counsel that is well versed in what needs to be in contracts and how to negotiate with the other side to ensure that the appropriate language is there in the contract to protect you. Those are the 5 things that you need to bear in mind when you are entering into a contractual agreement. If there's anything about contracts that you want to know, drop a note below and I'll see about doing a video on it. Until then, my name is Nathan, this is The Legal Good, and I'm out.